Did you know you can challenge the validity of a will before the courts of Ontario, where the person making the will was essentially coerced into doing so against their free will? That was the case in Abbruzzese and Tucci. Maria made a will in 2007 under which she left her house to her two daughters, Angela and Bernadette. In 2009, Bernadette moved in with Maria, who was living there alone. In 2016, Maria changed her will, essentially leaving all of her property to Bernadette. In 2018, Maria died. Angela learned about the will and challenged the validity of the 2016 will. After taking the evidence of a number of fact and expert witnesses and applying the 8 elements of the test set out in a case called Gironda and Gironda, and accounting for Maria's physical and cognitive vulnerabilities at the time she made the 2016 will, Justice Gilmore concluded that Bernadette had exercised overbearing power over Maria to get her to make the 2016 will, and declared the 2016 will to be invalid. In essence, Maria was afraid of being alone in her home. She was dependent on Bernadette for all aspects of daily living. She had turned Maria against Angela and otherwise exploited Maria's vulnerabilities. While there was no overt threat of abandonment by Bernadette if her mother did not change the 2007 will, there certainly was evidence that Maria had no options but to do what Bernadette asked of her, in fact, insisted of her. If you want to understand the various principles set out in the Gironda and Abbruzzese cases, reach out to us at CPLLP, and we can advise you of your rights to potentially challenge, or for that matter, oppose a challenge to the validity of a will. I'm Dan Chittiz, a litigator with CPLLP.